this video, we'll be covering real property for the MEE Highly Tested Topics Guide. To get started, the first thing that I want to discuss is that you should be aware of how real property is tested. Real property is tested on average about once a year, and it's usually tested on its own and not with another subject. We know that real property is notoriously difficult for examinees. So we recommend that you familiarize yourself with the vocabulary and you focus on those highly tested issues. So let's turn to the highly tested issues. The first issue that we have to discuss is deeds. There are two different types of deeds: general warranty deeds and quitclaim deeds. Turning to quitclaim deeds first, the grantee receives whatever interest the grantor has in the property, and there are no warranties. Whereas a general warranty deed has 6 covenants: the right to convey, season, no encumbrances, further assurances, quiet enjoyment, and warranty. Thus, when making a quick comparison of the two, it's obvious that a general warranty deed is the safest option because it comes with the protections or the warranties that the quitclaim deed does not. For example, if a person agrees to sell you a lot via quitclaim deed and you paid for the lot and accepted the deed, and then later you find out that they never really owned the land at all, and therefore you received nothing, you would be out of luck. This is because there are no warranties or promises that come with the conveyance of a quitclaim deed. You might be wondering, what do these covenants that come with a general warranty deed promise? Well, turning to the present covenants, first, the right to convey means the grantor promises that they can convey title. This means that they're allowed to do so. The covenant of season is when the grantor promises that they have title and possession. The difference between the right to convey and the covenant of season is best explained with an example. Let's say that Ashley owns a piece of land that she built a house on and she lives in it. But Heather has the right of first refusal. This means that Ashley may have the covenant of season. She has title and possession of the property, but she doesn't have the right to convey. This is because Heather has the right of first refusal. Before Ashley can offer it to another buyer, Heather gets the right to decide if she wants to buy it first. The last present covenant is the covenant against encumbrances. This is when the grantor promises that there are no easements, liens, or encumbrances on the property that are not stated in the deed. As for the future covenants, the covenant of further assurances means the grantor promises that if he forgot to do anything to pass title, he will do so. The covenant of quiet enjoyment is when the grantor promises that the grantee will not be disturbed by a third party, asserting a valid claim. And lastly, the covenant of warranty is the promise that the grantor will defend the grantee if there is such a third party claim. You'll notice that we classify these covenants as present or future, and it's helpful if you can do this as well, because depending upon the covenant in question, and thus whether it's a present or future covenant, it will dictate who can sue who. Turning to the 3 present covenants, those are the right to convey, season, and no encumbrances. Since these are present covenants, that means they run specifically between the seller and the buyer. So if they are to be breached, they will be breached at that moment the deed is handed over from the seller to the buyer. This means that only the buyer can sue the seller on these covenants. They do not run with the land. So future purchasers cannot sue the seller regarding these covenants. Now, future covenants are a little bit different. These 3 are the promises of further assurances, quiet enjoyment, and warranty. These covenants do run with the land, so when the seller sells a piece of property with a warranty deed and sells it to buyer number 1, if buyer number 1 sells the land to buyer number 2 at some point in the future, then buyer number 2 could sue the original seller on a future covenant. Because again, these promises or these covenants run with the land. Thus, you can see it's helpful to understand which covenants are present or future. The next highly tested topic is recording acts. First things first, I want to give you a little tip. This is something that so many examinees fail to do, and they're simply giving up rather easy points. When recording acts are tested on the MEE, the first thing you should do is discuss the common law default rule. First in time, first in right. So if O conveys land to A and then tries to convey that same piece of land to B and then to C and then to D, and there's a question about who owns the land, pursuant to the common law rule, first in time, first in right, who wins? Well, A wins the land. A owns the land. The theory behind this is that once O conveyed the land to A, he had nothing left to convey to B or to C or to D. That brings me to my next point. Grantors can only convey the rights that they have at the time of conveyance, which we see true in that previous example. So getting back to recording acts, many states have passed laws or recording acts that change the common law result. This is why we start our essay on a recording act issue with that common law rule. And then we move on to the recording act analysis. The purpose behind this is to be able to compare the outcomes. Who wins under the common law and who wins under the recording act. The purpose of a recording act is to change the common law result, and we won't know if it does unless we've analyzed both. There are 3 types of recording acts, and I will talk about each in turn. The first is a notice act. The language of a notice act will say something like, a conveyance of interest in land is not valid against any subsequent purchaser for value without notice unless it is recorded. The act has the word recorded, but it says nothing about first. A race notice act usually says something like, no conveyance in an interest in land is valid against any subsequent purchaser for value without notice unless it is recorded first. So this type of act mentions both notice and recording first. The final act is a pure race act. These protect a subsequent purchaser who records first. Notice is not relevant for this type of act. These are rare and they're usually not tested. My final tip for recording acts is that you should define notice for the grader. Oftentimes they are testing a race notice or a notice act, and thus the answer is going to turn on notice. Many examinees gloss over this when it should in fact be a major part of their rule statement as well as their analysis. There are 3 types of notice: actual, inquiry, and record. The mnemonic to remember this is AIR, A-I-R. The last highly tested topic I want to discuss is landlord-tenant law. There are a few points that are highly tested that should be on your radar. The first is assignment and subletting. This is permitted in a lease so long as there is no language in the original lease prohibiting it. Additionally, you should know the difference between assignments and subletting. If someone assigns their interest in the lease, this means they're giving everything that they have away. There is nothing left for them to come back to. When this happens, there is privity of contract between the landlord and the original tenant, and privity of estate between the landlord and the assignee, or the new tenant. If someone subleases their interest away, this means there is something left on the lease for them to come back to. When this happens, there is privity of contract and estate between the landlord and the original tenant only. If this is challenging to you, our tip is to look at who has the land at the end of the lease. If the original tenant has the land back, it's a sublease. If a new tenant has the land, it's classified as an assignment. Additionally, when it comes to landlord and tenant law, they like to test the duties that each respective party has. So the tenant's main duty is to pay rent. If a tenant decides to move out and they stop paying rent, the landlord can sue the tenant for damages, or they can treat it like a surrender. The landlord also has specific duties, which includes the implied warranty of habitability. This requirement is that the landlord has to deliver residential premises in a habitable condition. If the landlord does not, then the tenant can move out and terminate the lease, or they can repair the issues themselves and then offset that cost, or they can stay on the property and then reduce or withhold their rent. or they can stay on the property and pay rent, but then sue for damages. Our next tip for you to do well on the MEE is to learn real property vocabulary. Familiarizing yourself with the key vocabulary is helpful because you will encounter it in your fact patterns and it will make your answer stand out if you can utilize the correct terminology in your response. We recommend drawing positive attention to your vocabulary by bolding it or underlining those key words. In this guide, we have a list of terms that you should be aware of. Some examples include things like joint tenancies, as well as adverse possession. Our final tip for you to maximize your chances of success on real property MEE questions is to practice. As I mentioned earlier, we know real property is challenging for most examinees. So be sure that you're focusing on those highly tested issues when you study and that you're carving out time to practice MEEs on a variety of highly tested topics. That wraps up real property as part of our MEE Highly Tested Issues Guide.